Good morning, everybody. A little over 12 months ago, we looked at a case involving BHP and a prosecution that arose from a fatality at one of their work sites. Recently, that decision has been appealed to the Western Australian Supreme Court, and earlier this week, the WA Supreme Court handed down their findings. What I'd like to do in this presentation is do a quick recap of the earlier case, have a look at the findings from the Supreme Court appeal decision, and have a look at it particularly in the context of frontline risk assessment tools, things like the JHA process and the Take 5 process, to see what the cases tell us about the use of these tools, both as legal risk management devices, that is, tools to manage legal risk and the threat of prosecution or being sued, and also if there's anything we can learn from the cases about their use in safety risk management, and that is as a tool to manage health and safety risks in our business. Those of you who have seen these presentations before will have heard me say this before, but it's important that I say it each time. The conversation today is just a discussion about the general nature of the case and some of the legal and safety principles that arise out of it. It is certainly not legal advice, and it shouldn't be taken as advice specific to your business. Again, if there's anything that falls out of this case that you think impacts on your business or you think is important for the management of legal or safety risk in your business, then by all means I'd encourage you to go and seek specific advice about how it applies to your business. So just by way of a quick recap, the original prosecution had to do with a worker who was crushed while doing maintenance work on a scissor lift. In effect, the scissor lift descended while the worker was between the various bars of the scissor lift. He was caught and he was killed. There was no witnesses to the fatality, and as a consequence there was a lot of discussion about a lot of different aspects of the case. Technical discussion in relation to what he may or may not have been doing at the time. And one of the aspects of the discussion that was relatively important in the first decision, and certainly seemed to take on more importance on the appeal, was the question of this safety bar and whether it was used or why it was not used. And reading the cases, fundamentally the safety bar was a safety device that could have been used if properly positioned, to prevent the scissor lift from descending while a person was working on it. Now, the main aspect of the case that I discussed in the first presentation was around the frontline risk assessment tools, notably the Take 5 process and the JHA process. So BHP had these processes in place like most organisations in high hazard or industry generally, I have to say these days. And the evidence at first instance in the magistrate's court was pretty overwhelming. Those processes weren't implemented. The relevant worker had done few, if any, Take 5s, and a JHA hadn't been done for the job, notwithstanding that it had been going on for a considerable period of time. And that failure was one of the key reasons, one of the fundamental foundations, if you like, for why BHP was convicted. Now, in relation to the safety bar, on appeal, the West Australian Supreme Court in effect summarised the findings of the magistrate, and they said that the direct cause, so the primary cause or the operative cause of the fatality, was the fact that the safety bar wasn't put in place. And the other important finding that came out of the decision was that the worker who was killed, Mr. McLaughlin, was an experienced and conscientious worker. He knew about the hazards, and in particular, the evidence established that he had taken active steps to use the safety bar and had used it, in fact, twice on the morning of the accident. So, relevantly, I think, there's this important finding that the fatality occurred because the safety bar wasn't put in place, so that is the cause, if you like, of the fatality, and that Mr. McLaughlin knew he ought to have used the safety bar and had in fact used it that day. In other words, a key factual point in the case was that the failure to use the safety bar was the cause of the fatality. Mr. McLaughlin knew about the safety bar and he knew that he had to use it. Now, the magistrate at first instance made some important findings about the Take 5 and the JHA. The magistrate said that because Mr. McLaughlin didn't do the Take 5s and he didn't do a JHA, he hadn't addressed the hazards and controls associated with the work that he was doing. The magistrate went on further to say that there was a lack of supervision, and he said the lack of supervision, or if there had been proper supervision, it would have reinforced the need to address the hazards, and it would have provided, in the magistrate's words, an additional perspective on what controls should have been in place. And ultimately, the magistrate was saying that that lack of supervision contributed to Mr. McLaughlin's apparent lack of awareness about the hazards and controls. And what was really extracted from those findings was that the failure of the Take 5 and JHA process and the associated lack of supervision caused the fatality. So the failure of that process was a causal or operative factor in the fatality. Now, on appeal, the Supreme Court interpreted the magistrate's findings differently. The Supreme Court said, we've looked at what the magistrate said in the decision, and in our view, the magistrate did not make a finding that the failure of the JHA, Take 5 and supervision processes caused the fatality. At best, the Supreme Court was saying that there was some conjecture by the magistrate, and the conjecture was that if the JHA process was followed, if the Take 5 process was followed, if there was adequate supervision, then that process may have identified different ways to control the hazard. Now, the Supreme Court's view ultimately was that mere conjecture is not sufficient, and that there wasn't a proper finding that the failures of those processes actually caused the fatality. They said that there was no finding that those failures actually caused the death. They said that there was insufficient evidence based on the facts to establish that a causal link with death was established beyond a reasonable doubt. There had to be more than mere conjecture, and there had to be some reasonable causal relationship between the relevant failures, that is of the JHA, supervision and Take 5, and the actual fatality. And on the basis of the findings of the magistrate, that relevant causal link wasn't there. So the question is, well, why does that matter? Fundamentally, it goes to an issue of penalties, if nothing else. Under the Mine Safety and Inspection Act, which was the piece of legislation BHP was charged under, Section 9A creates 4 levels of penalties, from the most serious being Section 9A1 of gross negligence, down to the least serious 9A4. Now, the relevant provisions of interest in this case were 9A2 and 9A3. So 9A2 says, if I breach Section 9A1, and just to put it in its simplest terms, if I as an employer don't do everything reasonably practicable to ensure that my employees are not exposed to hazards, I commit an offence. So if I commit that offence, if I don't do everything reasonably practicable and my employees are exposed to hazards, and that failure causes death or serious harm, I am exposed to a level 3 penalty, which is a high penalty. If I have exactly the same failure, that is, I fail to do everything reasonably practicable to ensure that my employees are not exposed to hazards, it might be the same failure as for 9A2, but that failure does not cause death or serious harm, so I cannot establish that causal link, then I'm exposed to a level 2 penalty, which is a significantly lesser penalty. So the issue of causation goes fundamentally to the question of penalty under the Mine Safety and Inspection Act. So originally BHP was convicted under section 9A2, being the more serious offence, with the finding that that failure caused the death of Mr. McLaughlin. Even though BHP was successful on appeal, they were still convicted of an offence. The Supreme Court said the failure to comply with your own procedures, that is your JHA, Tape 5 and supervision processes, was a breach of the Act in that you hadn't done everything reasonably practicable by way of instruction and supervision to ensure that your employees were not exposed to hazards. But that failure did not cause the fatality, because the operative cause of the death was the failure fundamentally to use the safety bar. So in other words, even though BHP had failed to comply with its own procedures, those failures did not cause the death of Mr. McLaughlin, and therefore the conviction against section 9A2 was quashed, so the appeal was successful. But the court had powers under the Mine Safety and Inspection Act to substitute that with a conviction under section 9A3, and that's what they did. And the court hasn't published the penalty it intends to impose yet. Presumably there'll be further hearings on what level of penalty should be imposed, and if we find out about that, obviously we will update you and let you know. Look, I think this case, and it's a discussion I've been having for a long time, but I think this case really creates an interesting discussion around the JHA process. Because on one level, and this case is a perfect illustration, on one level there was no evidence led that there was anything that could have gone into the JHA that would have prevented this fatality. So there was nothing to suggest that as a tool this frontline risk assessment process would have prevented the fatality. But at the same time, the failure to comply with their own process, irrespective of the fact that it didn't cause the fatality and irrespective of the fact that following it probably wouldn't have prevented the fatality, created legal liability. So the failure to comply with their own process creates a legal risk. Doing the process might have prevented the accident, although in this case it seems pretty strongly to suggest that even if we had followed our own process, the fatality wouldn't have been prevented. So it kind of raises a question of, what value is the JHA process if it's not being used as an effective legal risk management tool, and quite frankly, it's probably not being used very well as a safety risk management tool. My own experience, and I've been involved in a couple of significant projects over the last 6 months with a range of different organisations at this frontline risk assessment level of JHA's Take 5s, including talking to project managers and chief executive officers about how well they think the process works. And my own experience is really no one does them well. And beyond that, everybody knows that they're not done well. When you sit down with a group of managers or supervisors or workers and you point out all of the objective errors, and I'm not talking about subjective assessment, I'm not talking about I think you've rated this risk too low subjectively, I'm talking about really objective issues whereby the JHA process says you will fill out this box and the box is not filled out, or the JHA process says this is the risk matrix you will use and a different risk matrix is applied. Universally across the board, from an objective perspective, JHAs are not done well. People know they are not done well. They struggle to get them done. Workers sign on to these things without reading them. We review them without checking them. We just sign off that they're done. And they sit there, quite literally in my view, as pieces of evidence in legal proceedings just waiting to blow up in our faces. At the same time, adding very little, if any, value at all to the management of risk on a day-to-day basis. When you go and talk to workers on a work site, you actually sit down and have a discussion about what are the risks, what are the dangers on this site, what are the things that can kill you. They know what they are. and they all talk about them in pretty much the same way. When you try and relate those conversations back to what is written on the JHA or the application of the JHA process, they are totally disconnected. There is almost no relationship between what the workers are doing on a day-to-day basis to manage their risks based on their experience and the level of supervision and their training and what they have actually put down on the piece of paper. My overwhelming perception is that workplace risks are managed to a greater or lesser extent at a workplace in spite of the paperwork that we ask our workers to do, and certainly not because of it. And if anything, my personal experience is that the paperwork actively undermines effective safety management. There's also a question beyond my experiences and discussions in this in terms of what does the actual research tell us. And I think that this particular piece of research captures very well both my experiences of working with people around frontline risk assessments and almost the universality of the research into this. And that is the paperwork that we're generating actually creates an illusion of safety, this idea that we're doing all of this activity in the name of safety, filling out all this paperwork, therefore the risks must be controlled, and the reality is that's just not true. And as is suggested in this article, the overemphasis on the paperwork is probably detracting from the intent and the effectiveness of the program. And so it seems to me that if we are just generating paperwork that creates legal liability for us and that does not actually contribute to our management of the risk, perhaps it is time to have a serious discussion about the place of the JHA in safety management. Without wanting to be overly pessimistic on these frontline risk assessment tools and the paperwork, I think it's fair to say that if you're using JHAs to manage your legal risks, they probably aren't. If you're using them to manage your safety risks, they're probably not doing that either. And ultimately, you will not know unless you go and check. Now, if I can describe a scenario for you, I was working with a group of executive managers and I had a collection of JHAs that I randomly distributed, and I asked the management team a question on a scale of 1 to 10, how crucial is the JHA process to the management of risk in your business? And individually and then collectively as a group, they all agreed it was between 8 and 10, with 10 being very critical. So as a management team, they were saying, yes, the frontline risk assessment tool, the JHA process, is a critical part of our process to manage health and safety risk in our business. And that's I've been asking that question of management groups for about 4 or 5 years now, asking it of supervisors, and that's the universal experience. So we distributed the JHAs. I hadn't selected them for quality, they were just randomly provided to me by the business. And I said, I'd like you to review this JHA and then explain to me what the risks on this work are and how the JHA is designed to control those risks according to the JHA. And then I want to have a discussion with you about how confident you are that these processes are effective to control the risks in this business that you are responsible for. And we're only halfway through the exercise when at least 2 of the managers were on their iPads booking flights to get out to their projects because of the level of concern they had about whether or not the risks on their projects were actually being managed, because the documented systems reflected an absolute disconnect between what their expectations were about these processes and what they were actually reading. So unless you are actually going out and checking not only the paperwork, but that the paperwork has some relationship to what's actually happening in your business, there's a significant risk that you are creating real legal liability for yourselves, and more importantly, simply not managing the risk in the business. Okay, well, thanks again for tuning in. I hope you enjoyed the presentation. If you want to get some more information, you can follow me on Twitter, you can go to the blog website and follow the blog, and that will send you these updates automatically, or you can go to the website to find out more about us. But once again, thanks for tuning in, and I look forward to catching up again next time.